The South African labour market is undergoing a major transformation with the new employment equity regulations published on the 15th of April. Now, these new rules aim to enhance workplace inclusivity and transformation nationwide. Adv Tertius Wessels, Managing Director at Strata G Labour Solutions, joins us now to explain how the Democratic Alliance's court case against the Department of Labour affects the implementation of the new Employment Equity Act regulations. Well, good afternoon and thank you for joining us.
Good afternoon and good afternoon to the viewers.
How is the DA's court action challenging the legitimacy or enforcement of the new regulations?
So the DA's case against the Minister of Employment and Labour seeks to challenge the Employment Equity Amendment Act, and in particular Section 15A of the Amendment Act. Now, this section effectively empowers the Minister to identify national economic sectors and to then set targets for the equitable representation of designated groups within those particular sectors. So where businesses once had the ability to set their own goals or objectives, they are now effectively required to meet government-imposed targets. And what the DA argues is that this amounts to almost rigid racial quotas. And what we've seen from the arguments in the case is that the DA seeks to challenge the legitimacy and enforcement of the Amendment Act on two grounds. Firstly, they are challenging that it's invalid because it was incorrectly tagged. Now, when we talk about tagging, it's important to mention that the Constitution effectively prescribes that there are one of two processes that needs to be followed when an ordinary bill gets passed. If a bill does not substantially affect the interests of provinces, it gets processed in terms of Section 75. However, if it does substantially impact on the interests of provinces, then the bill should follow a process set out in Section 76. And the choice of choosing is called tagging. And it is Parliament's tagging committee that ultimately decides whether a bill should pass via Section 75 or Section 76. In this case, the DA argues that the bill is a 76, should have been tagged as a Section 76 bill, but it was passed via Section 75, and therefore it is in its entirety invalid. Now, even if the court does not agree with the DA on the issue of the tagging, they are still arguing that Section 15A of the Amendment Act should be declared unconstitutional because it violates Section 9 of the Constitution, which guarantees equality and ensures no unfair discrimination. And that's simply because the target or what has been set by the minister gives him excessive powers and effectively would then discriminate against those that do not fall within the designated groups, and it will potentially be harmful for employment.
Tertius, tell me now, what happens if the court rules in favour of the DA? Could this court case then result in current implementation timeline for the new employment equity targets being cancelled or pushed out?
Yeah, so it very much depends on if the court, for example, agrees with the DA's argument on the tagging issue, it effectively means that that legislation becomes invalid and unenforceable. And that means that we then have to revert back to the Employment Equity Act as it existed prior to the amendments. However, if they're not on the same par with the tagging issue, then the other question remains is that if Section 15A is declared unconstitutional, what happens then? Because we know that the Constitutional Court is ultimately the court that can confirm whether or not a particular section of an act is unconstitutional. And in that regard, one would have to argue that if the Section 15A is found to be unconstitutional and invalid, it stands to reason that the employment equity regulations, which is in power or it comes into existence through Section 15A, should be set aside. So yes, there would be a delay in as
Yes.
far as the implementation of the new regulations
Sure.
is concerned. But businesses would ultimately have to default back to what the Act was prior to the amendments.
Now, in the meantime, should employers comply with the new regulations yet, or wait for the outcome of the DA's challenge?
At this point in time, the reality is that the regulations are law, they are
Yes.
valid, and they are in play.
All right, okay.
And if one looks at these regulations, it requires employers with effect from the 1st of September 2025 to implement a new 5-year plan up until August of 2030. So it would be advisable not to sit on your laurels at this stage, but to focus on implementing or doing a proper needs analysis and ensuring that you are doing what is necessary to implement the plan come the 1st of September.
And then lastly, what impact could this have on transformation efforts in the workplace, especially in sectors with historical inequalities?
Yeah, it's going to have a significant impact. Doesn't matter how you look at it. Many may see, if the DA is successful in their court case, that this weakens transformation efforts in sectors, especially where there has been underrepresentation of designated groups.
Yes.
Whilst if the DA is unsuccessful, many may see it as now putting a more stringent onus on businesses to
Yes.
comply. Because at the end of the day, the only way that businesses would ultimately be able to justify not obtaining the target set by the minister is if they are able to provide adequate reasons for not being able to recruit people into the roles.
Thank you so much, Advocate Tertius Wessels, Managing Director at Strata G Labour Solutions.